Consumer protection. One of the core tenets of the law of contract is that of the freedom to contract, that within the confines of legality, parties should be able to agree whatever they like between them, and to be bound by that agreement. Where parties are of equal bargaining power, this seems a very reasonable position to take. From the perspective of certainty, it allows parties to enter into agreements knowing that what they promise, and have been promised, is legally enforceable. Where the parties are not of equal bargaining power, absolute freedom of contract would permit a stronger party to impose terms on the weaker party which were unfair, simply by virtue of their greater bargaining power. In this podcast, I will discuss some of the tools used within the law of contract to try and restrict to the extent to which parties with lesser bargaining power, in particular consumers, can be subject to terms which are unfair or unreasonable. Section 14 of the Sale of Goods Act 1979 is a term which gets quite a lot of attention, probably because it is the obvious legal recourse to a consumer who has bought goods and found that they are shoddy or break under reasonable use. Section 14 provides that where the seller sells goods in the course of business, there is an implied term that the goods supplied under the contract are of satisfactory quality. This is a general test under Section 14.2. There is a more specific requirement under Section 14.3, which is that where a buyer makes known to a seller any particular purpose for which the goods are being bought, there is an implied term that the goods are reasonably fit for that purpose, even if it is not for the purpose for which the goods are commonly supplied. There is an exception to this, and that's where the buyer does not rely on the advice of the merchant, for example, where they had already made up their mind as to suitability. The second exception is the situation in where it is unreasonable for the buyer to rely on the skill or judgment of the seller. For example, if the seller's representative makes it clear that they are occasional staff and not an expert in the area, and the buyer insists on asking very technical questions about an unusual use of the product, they will not be able to bring a claim for breach of the implied term of satisfactory quality if the product does not, in fact, do what they want. In the podcasts on limitations of liability and exclusion clauses, I discussed that the third step of analysing such a clause is to consider the extent to which, even if incorporated into a contract and on a true construction covering the breach, it still falls foul of statutory limitations. And I talked about the Unfair Contract Terms Act of 1977 and the Unfair Terms and Consumer Contracts Regulations of 1999 and, more recently, the Consumer Rights Act of 2015. I don't propose to cover the material on the first two statutes again here, but suffice to say that there are a number of frameworks which attempt to prevent stronger parties from limiting their liability or the effects of under or non-performance on their part in a way which adversely affects the rights of the weaker party to such an extent that the term is unfair. Where a consumer purchases goods or services at a distance, for example over the phone or over the internet, they will not have had an opportunity to examine the goods or to check that they're getting what they're expecting. Because of this, strictly enforcing the rule that, as a matter of general principle, there is no right to repudiate a contract simply because you didn't get the bargain you were hoping for, would be unfair. There is now quite a substantial body of rules dealing with online and distance contracts, and I will consider these in a separate podcast focused just on that. The last framework that I would like you to consider in terms of granting rights to consumers is that of the Consumer Rights Act 2015. The Act consolidates the various rules on consumer protection into one central place, and this includes the rules on exclusion of liability. You might want to take a look at sections 31, 47, 57, and in particular at Schedule 2 if you haven't already done so. I'm not going to dwell on this particular piece of legislation, but instead I suggest that you take a look at it and see how you feel about it. It's written in what is supposed to be consumer-friendly language to enable consumers to understand their rights by reading the primary legislation without recourse to solicitors. This is a very good idea, but it remains to be seen how it works in practice. One of the advantages of the language that we probably use, that we describe as legalese, is that interpretation of law is generally made easier by using language in a very precise way, with words having clearly understood meanings. Using everyday language may make it easier for the consumer to read the legislation, but this may come at the cost of clarity or of ambiguity. I may be wrong, this may be a great idea, and time will tell, but I am slightly fearful that in trying to make the legislation easily readable, it's actually going to open a can of worms and cause more problems than it actually solves. The Consumer Protection from Unfair Trading Practices regulations of 2008 is an important part of the overall fabric of consumer protection, but it doesn't grant rights to consumers as such. Instead, as the name suggests, it prohibits unfair commercial practices and tries to influence the environment and the operation of companies selling to consumers. There are two tests. The first is that a commercial practice is unfair if it contravenes the requirements of professional diligence, and it materially distorts, or is likely to materially distort, the economic behaviour of the average consumer with regard to the product. The second test is that a commercial practice is unfair if it is a misleading action, which causes or is likely to cause the average consumer to make a decision where he would not have otherwise taken it, it's a misleading omission, or it is aggressive in that it is significantly likely to impair the average consumer's freedom of choice or conduct in relation to the product concerned through the use of harassment, coercion, or undue influence. It also includes a list in Schedule 1 of practices that are automatically considered unfair. Do take a look at Schedule 1 and see the kind of things that are automatically unfair. These include sort of running false promotions, running pyramid schemes, pretending to be running a closing down sale when that's not true. It also includes something which I see quite a lot. This is at paragraph 20 of Schedule 1, and that's describing a product as free or similar if the consumer has to pay anything other than the unavoidable cost of responding to the commercial practice and collecting or paying for the delivery of the item. I think it's still reasonably common to see things described as free with this magazine, when actually what they mean is included in the price that you're already paying for the magazine. To summarise, consumer protection is going to be central to many systems of contract law to prevent the potential for a stronger third party, a business, to abuse a consumer's generally weaker bargaining power, to impose obligations on them, or to unreasonably limit or exclude their liability. This consumer protection framework may include implying terms into consumer contracts to ensure that consumers have certain contractual rights, to prohibit unfair terms, as well as to impose limitations on the behaviours of third parties in their dealings with consumers.